Make vigilant. Well, Lord, in respect of the two criminal contempt matter which Lordship was pleased to hear yesterday, well, I've got just 2-3 aspects to point out. I've informed the other side, my Lord, that I'll be going to mention. Somehow they are not present. My Lord, my first concern is in the cause list which was published yesterday, my Lord, there one K.K. Datta petitioner in person has been shown. I'll just hand over the copy, my Lord. Hey, today. Now, this was the cause list, my Lord. Now, I have not been served with a copy of the petition. I don't know. Now, when the Advocate General is petitioner number 1, as was read out yesterday, and in person it was petitioner number 2, my Lord, how come this K.K. Datta is a petitioner in person? That is an aspect I'll submit, my Lord, Lordship would like to look into it. Because at page number 2, this is the status of the case which we have taken from the registry, my Lord. This also reflects the same position. Therefore, is it a case of 15B that I don't know, my Lord. So that is an aspect which your Lordship will look into. That is one aspect, my Lord. Therefore, we do not know, my Lord, subject to correction, it could be a case. It may not be under 15A, 1A, it could be under B also. Therefore, that is an aspect which needs to be looked in. My Lord, second aspect is, there is a post, my Lord, in this channel called Pragnis. In vernacular, it says, association or ekanko odhiboktar birudhe gusor riju. When we literally translate it into English, my Lord, criminal case has been registered against a section of the lawyer of the association. This is a post. And this has been liked by none other than Honorable Justice Punni Krishnan Nair at page number 4.
Is the like, sir?
Yes.
Is the like?
On the left-hand side, my Lord, the thumb.
It is the thumb.
Yes.
It is not a thumb.
Yes.
It is not a thumb.
Yes. On the left-hand side, top, my Lord. So when his lordship,
It also says mention.
my Lord,
So
therefore, the news item, no, it's for your lordships. It is my duty to point out. I'm just pointing out. Now, here is a news item which says some lawyers of the association are being booked under criminal law. A judge who is adjudicating the issue, honorable judge, and he is liking it. So therefore, in my humble submission, his lordship should recuse from the case. That's my submission, my lord, and for your lordship. And in case, my lord, your lordship decides not to recuse, and if your lordship is...
sir, that we will decide.
Yes, yes.
That we...
Then, my lord, if your lordship, in spite of that, lordship decides to go ahead with the case, my lord, 2 judgments I'll rely, my lord. I'll like to serve copy on the other side also. On, my lord, that in a contempt, my lord, in a contempt, issuance of notice is not an, normal job. It's not a casual or a matter of course. For that, my lord, I'm relying on 2 judgments. One is, my lord, I'll hand over the copy, my lord. 2024 SCC online, Allahabad. Then, my lord, 1972 1 SCC Supreme SCC 573, para 13 and 14. And this 2024 SCC online, Allahabad 4660, para 23. Yes, I'll just now complete that video. Well, both the judgments we are handing over. The print out video. That's all.
Adjournment request, if any, from item number 1 to 6. From item number 7 to 15. Adjournment request from item 13 to 25.
May it please your lordship.
Yes,
With the consent of the other side, I beg to mention item number 25, lordship.
item number
25,
25.
yes.
Adjourn.
Lordship, I am for the respondent on behalf of SKM.
Wait for it.
I am for the respondent, Lordship, for SKM.
Yeah. well,
Obliged.
Lordship, with the,
Consent is not objected.
Lordship, with the consent of the respondents, Lordship, I wish to mention item number 23 and 24, Lordship.
23 and 24. Yes,
Lordship.
what do you want?
Lordship,
What do you want?
I want Lordship 3 weeks time, Lordship. After 3 weeks, Lordship.
Jan, August.
I am for the respondent, Lordship.
May it please your lordship,
No
lordship, I-
objection? You have no objection? No objection, no.
may it please your lordship, I beg to mention item number 22, lordship.
22.
Can be-
Adjourn.
Adjourn, lordship, after 3 weeks, lordship.
August.
Lordship,
Take your own time.
obliged.
Any other request?
My pleasure, Lordship. Lordship, under compelling circumstances, I am seeking indulgence of your Lordship to move in repetition criminal Lordship to the unlisted.
Approach the registry. I'll give you the.
Daily list for orders item 1.
Same 1 minute, I have taken the dusty service, but notice has yet to be served upon the respondent sole response minute.
No, that's the.
I have received the dusty from the department, registry minute.
Receipt, post receipt, no affidavit,
Yes, madam.
then consider. For the, take some more time, take some time to.
Serve the
file
copy,
an
madam.
Additional affidavit regarding the justice service upon the respondent number 1,
Oblige, Lordship.
just after 3 weeks.
Item 2.
Lordship, we are filed order dated 28, lordship, register steps as well as Dusty was directed to take. I have taken register steps, it was sent on 7/4. Dusty, the process I have completed, lordship, but difficulty is that the battalion is posted at Chhattisgarh and the petitioner is a resident of native village of Kashmir, lordship. And one more thing, lordship,
Take fresh steps.
register step on 7/4 already issued. One more thing I want, 7/4 office notice there. Register. Office notice there, 7/4.
Await return of notice of answered respondent for 6 more weeks.
Obliged.
Item number 3.
This method,
The bench.
deeply
The colleague.
Item 4.
This is an appeal mallet preferred by the state mallet. While preparing the appeal mallet, there is a delay of 320 days mallet.
Is on merit.
Merit mallet, the only ground for preferring the appeal mallet there was a direction from the Honorable Single Judge to consider the case of the petitioner without following the guideline for appointment or compassionate ground, my lord. That is the ground, my lord. But kindly come to page, the impugned judgment, my lord. It starts from page 55 in the memo of appeal.
Yeah.
The relevant paragraph, my lord, the last paragraph, my lord, page 65. Paragraph 14. Under such peculiar circumstances, this court, under the powers conferred on this court under Article 226 of the Constitution of India, to issue a mandamus to the Respondents Department, namely Respondent number 1, Commissioner and Secretary, Assam Education Secondary Department, to forward the relevant papers pertaining to the appointment and the service rendered by the petitioner to be placed before the Chief Secretary of the State. The Chief Secretary of the State, in capacity as the chairperson of SLC, will treat the order dated 11/6/2013 passed by the Director of Madrasa to the recommendation from the District Authority or DLC, and will thereafter pass necessary orders as required under the office memorandum prevalent at the relevant point of time for compassionate appointment. This specific order is passed on by the court in view of the fact that petitioner was permitted to work by the order passed by the Director of Madrasa dated so and so, and that order as on date has not been recalled or reviewed, and the petitioner was made to work without payment of any salary. Upon the matter being placed before the Chief Secretary in his capacity as the chairperson of SLC, the SLC will pass necessary orders regularly. The approval of the petitioner as a compassionate appointment with effect from the date of the order being passed, and the matter be forwarded to the Finance Department for grant of prospective approval to the post in which the petitioner has been appointed. This order shall not be treated as a precedent, as this order is passed under peculiar facts and circumstances arising in this case before the court.
Still you are challenging.
So,
Still you are challenging.
well,
One individual admittedly working since 2013.
yes, that is
12
there, madam.
years have passed, and you are challenging his appointment or whatever on a very technical ground. It was not by so and so. And the learned single judge has made it clear that it could not be treated as a precedent. Very peculiar facts and circumstances of the case. This order has been passed. Despite that, you are getting too much.
Only thing is the procedure.
What only thing? Only thing.
Because in respect of compassionate appointment, there
Is it a precedent?
no, my lord,
Can
no,
be treated as a precedent?
no, my lord, certainly not, my
One
lord.
individual case, if the learned single judge exercises this equitable jurisdiction, where is the reason for the division bench to interfere with this order?
That is the only ground, my lord, I have.
That is the, how you can take this ground, sir? Such an order.
Obliged, lord.
Hey, listen. Having heard the IML, having heard that this IA is preferred on behalf of the applicants with a prayer to condone the delay of 320 days in filing the connected writ appeal. Stop. Then it concept. Item number 4. So this writ is already, the writ appeal is already registered or it's a filing number?
No, my lord, it's a filing number, my lord.
Filing number.
Likha one. Filing number. क्या लिखा? The IA with the prayer to condone the delay of 320 days in filing the connected to the top. Planet concept. Appearing for the council appearing for the sole respondent has not seriously opposed the application. Full stop. Looking to taking into consideration that short controversy is involved in this petition, we deem it appropriate to condone the delay of 320 days in filing the connected writ appeal the registry is directed to register the conductor date appeal immediately. Full stop. Then after registration, the consent of the parties, the matter is heard finally.
Obliged.
Item 5 to 12.
My lord, the I is for condonation of delay. And the
Condone.
merit of the case,
Condone,
my lord,
delay condone.
that your lordship provided me the copy of the judgment and order
Which
passed in the
copy?
case of Jugeshwar Sahu and others. last
Zaidu-
occasion.
This,
It is no- My lord, in my-
Yogeshwar Sahu.
yes,
Yes, so
Jugeshwar
what do you
Sahu.
want to say?
My lord, in my consideration,
Yogeshwar Sahu. Yes,
in my consideration, that is not squarely covered of in an instance case, my lord, because here the this order has judgment and order has been passed in the light of the Roughing Mercy case. Undertaking aspect is not mentioned here. Right. Hello, here. The circumstances on which the payment has been made and aspect of undertaking is not considered here.
yeah,
Aspect of under which circumstances we have to pay the excess amount and the revised pay scale. That's not considered here. And that is why possibility was there, my lord. Because of that, the government of India issued a notification or office memorandum dated 28/2008 that
saying that, stating therein that there may be possibility of calculation excess payment. Therefore, the authority who disburse the amount must obtain undertaking.
So,
Yes, my lord, in the case of High Court of I have annex in annex
what to say about this Lotus judgment?
judgment, my lord, judgment annex
4th of April.
the High Court of Punjab and Haryana and
That has been taken into consideration, sir.
Uh,
See judgment.
258, my lord.
Rafiq Masih.
Punjab and Haryana and Jagdeep Singh. At 258 of my memo of appeal, my lord.
Okay.
256.
Fine.
256.
When this excess payment was made, in which year this,
My lord,
in which year this excess payment was made?
2008, my lord.
2008.
Eight.
And now,
My lord, that with retrospective effect from 116, my lord.
okay, fine. 2008 is the date when first time the excess payment was made, and now it's, how many years have passed?
My lord, excess payment, wrong calculation.
Yes, wrong
Over
calculation,
excess amount.
admittedly, without there being any misrepresentation and fraud on the part of the respondents.
No fraud, my lord.
No fraud, no
No
misrepresentation.
more.
2008, the excess payment for the first time was made. Now you want to recover it in 2025.
Continuous payment, my lord.
Yes, continuous payment. It was the mistake occurred way back in the year 2008. And thereafter continuously they are getting some excess payment. This is what they have also filed an undertaking that in case excess payment, they'll return that. Anything else? But after 5 years of the period when this first time this mistake occurred, whether you can short for recovery.
My lord, the fact of excess payment come to light during the audit period 2017 to
So that
2020.
is also after a period of 5 years.
No, after 5 years, but in
The
the
2008 and 2017, certainly after a period of 5 years. The learned single judges, this rejected your review petition while taking into consideration the clause 3 of the Rafiq Masih judgment.
yes,
Recovery from the employee when the excess payment has been made for a period in excess of 5 years before the recovery order is issued.
but
That is what the only reason.
but
And that is the admitted position.
admitted position, my lord, and clause 5 also says that the circumstances is to be considered by the
If any other case where the court arrives at the conclusion that recovery is made from the employee would be incautious and harsh and arbitrary to such extent as would be outweigh the equitable balance of the employer's rights to recover, then also recovery can't be made. We find in both these clauses, the cases
Yes.
of the respondents are covered.
My lord, as my Punjab and Haryana and Jagdeep Singh case,
Yeah.
this the Rafiq Masih case was taken into consideration. আমার আর দুটো জাজমেন্ট আসলে যে এই বিষয়ে যেমন ওটা that was considered and the honorable court observed that the excess payment made to him must be returned or adjusted in suitable installment. And in another case, Sandeep Prasad, Udayan and others, same view was taken by this honorable Supreme Court. But it was It was paid earlier, but after retirement also.
That's all.
And another is that, my lord, the common order passed in the for writ petition is setting aside one communication of the year. My lord, at page, my lord, page 28, my lord. Twenty-eight, 11%, 45. That impugn communication set aside by this honorable court by the common order is 25/6/2021. But in the writ appeal number 51, it is different. It is an impugn order there was 30/11/2021.
This IA is for 795 days.
Yeah, my lord.
Okay. This item number 5, 795 days, and 6, 7, 8, 9, and 10, in which all these this already condoned.
Con-
11
Three
and 12.
cases not condoned.
11 and 12, again, IAs for condonation of
No.
delay. Is what
My lord. Maybe condone, my lord, all parties here,
may be condoned, let them ask.
your lordship.
Yes, sir. You are referring for all the,
Yes,
in all these matters. In all these matters.
yes, sir.
The matter comes up for consideration of IA number 642 of 2025. 641 of 2025 and 1085 of 2025. With a prayer to condone the delay of कितने दिन का delay है? How many days delay in that?
795 days, my lord.
795. And what about 641 में?
6141. The same day, my lord, we have filed, my lord.
Respectively, so and so days delay respectively. Please notice that against the impugned order passed by the learned single judge, several writ appeals were also filed with the delay, and this court was pleased to condone the delay in those cases. Full stop. Learned counsel for the respondent appearing for the non-applicants in the above referred IAs is not in position to dispute the said fact. In such circumstances, the IA number so and so, so and so, and so and so, so and so are allowed. The delay in filing the connected writ appeals are condoned. Registry is directed to register the connected writ appeals immediately. Full stop. The writ, writ appeals, these writ appeals.
52 को रख सकता हूँ.
These writ appeals are heard
52. ये आता है.
along with the, are heard, final, are heard, the final arguments in these writ appeals, as well as in the writ appeal number 50 of the 2025, 51, 52, 79, 107, 2025 are heard with the consent of the party. Order reserved.
My lord, one my prayer is that in 50 also, rate appeal number 50 of the term, interim may continues because interim may be
Final
considered
order. You are asking for an interim order.
because
And I think so you get the impression what we are going to do. You
Yeah,
already
but-
got this impression what we are going to do.
my lord, that may be fixed for the rate appeal, for listing the rate appeals.
We
After
have
you.
already heard finally what is the question of listing. We have heard finally order reserved. Ready.
Only one aspect I just wanted to insist your lordship. Para 5 of the first writ petition judgment, he himself says, Rafiq Mashi applies. Malindi applies.
Item 13.
Item 13 and 14 listed for the first time, notice.
Issue notice. Issue notice of IA number.
Okay, no,
returnable.
Item 15.
This is the first time.
First time, delay
Notice of the IA number 24 returnable.
For admission, item 16.
Returnable 60.
There is another connected matter, my lord. The petitioner has filed 2 cases, 5624 of 2024. In that case, my lord, my affidavit it has come. My lord, I am filing the affidavit. Our affidavit has come, my lord. We are filing the affidavit in the matter today. My lord, both the cases may be taken up together, my lord. Here, the provision of 1964 Act has been challenged. The validity of the 64 Act.
taken up together.
1964.
The state acquisition act.
The state acquisition act has been challenged, my lord. The one affidavit that will cover, my lord.
List along with number.
WPC 5624 of 2024.
The next date in that matter.
My lord, there is no date.
There is no
given.
fixed date for it.
No date. given.
List along with one.
Lordship.
At the request of the party, list along with one.
They may file their reply in the meantime. They may file their
My
reply
lord,
in the
we are filing it.
They are open.
Lordship. Acknowledged.
Item 17.
5624. 5624. 20.
My lord, before my learned senior sir submits, my lord, my humble prayer would be that this matter may be tagged along with my lord read up in my lord
They-
119, my lord. Similar arising out of same.
Because here your lordship has indicated on that day, and it is not, I have looked into the file, it is not by the principal, it is by the society which was registered, and it is by this case, it is by the governing body. Now to nullify it, that 10 years, I am not below 10 years. Now yesterday, before yesterday, the certificate was issued by the principal. Said I have been working since 2011. Temporary I was working. I can show it. There are annexures which shows by the authority concerned that 2011 I have been working.
List along with.
WA 119 of 25. Okay.
Clear.
Item 18.
Wait, please. My lord, in this matter pertains to a tender process. There are 2 aspects. One pertains to the conduct of the repetition of before the learning single judge, and the other on merits. Even on conduct, there are 2 aspects. I'll first take your lordship to the first issue straight away. If your lordship will first turn to page 124. This is part of the NIT. The NIT starts at page 90. Right at the bottom of page 124, your lordship will find notification of award. And if your lordship kindly turns the page, in fact, my lord, what has been done under this NIT is notification of award means the phrase used for work order. Now, 33.2, the notification of award will constitute the formation of the contract. Now, this notification of award was issued at page 234. So, lordship will kindly note the date. Page 234.
Just a minute. Yes.
If your lordship kindly comes to page 234, your lordship will kindly note the date, 14th of January 25. The notification of award is issued.
Notification of award means award of contract,
Award of the contract, the work order.
work order.
Work order. And it is clearly stipulated in the NIT that will constitute the contract. Formation of the contract.
What is clearly stipulates?
I just pointed out, clause 33, that notification of award.
Is notification of award will constitute a formation of contract. And this you mean the notification of award is dated 14/1/2025 means, which means work order is issued.
Now, in the second week of February, the writ petition is filed and moved, and the statement made in the writ petition is at page 74. Page 76, I'm sorry. Eighth line from the top, my lord. Your lordship will find a sentence starting now pursuant.
Yes.
Now pursuant to the opening of the financial bid in respect of the NIT dated 6/6/24, it has come to the knowledge of the petitioner that notice of award, your lordship will kindly note. Tactfully, they don't use the word notification of award, notice of award, as if some kind of a notice has been given. Of award has been issued to the respondent number 5 on 14/1/25, but no work order or contract has been signed with the respondent number 5. This is the statement made on oath.
Okay.
Now your lordship will kindly come to the interim order That is at page 237. And the submission made before the learned single judge. This aspect is not even brought to the notice. That notification of award is not even put to challenge.
This was the ex parte order.
Yes. Now, the interim order starts at 237.
Two,
237.
yes,
And the submission made before the learned single judge is recorded at page 241.
yes.
Line about 9 from top at 241. Towards the right hand side, your lordship will find a sentence starting, however. However, has my lordship quoted. However, it is submitted that the respondent authorities are proceeding to allot the tender in respect of the private respondent number 5. Mr. So-and-so therefore submits that interference of this court is necessary to restrict the process undertaken by the respondent authorities for allotment of the tender in respect of the respondent number 5, who is clearly not qualified in terms of the eligibility criteria provided. And based on this, as if the process has not culminated in the work order, the process is underway. And based on this, the interim order passed is at page 242, paragraph
I
8.
will not proceed to allot the work order.
Whereas the work order was already, that is the first part so far as the conduct is concerned. Now coming to the merits of the case, Madam. If you,
Then you have pointed it out to the learned single by filing vacation application.
no consideration of that.
What happened?
My lord will kindly come to page 27.
Page 27.
Not just this, even on merits, we had pointed out that he has taken the benefit of the same clause. And
That merits will consider later.
my lord. If your lordship will kindly come to para 5, starts at page 27. The fact that the notification of award was already issued starts from para 5.
You just read the whole order.
My lord. Heard Mr. So-and-so, so-and-so. By this application, the applicants who are the respondent numbers 1, 2, 3, and 4 in WPC number so-and-so are praying for vacation modification of the party interim order dated so-and-so passed by this court in the said writ petition being the WPC number so-and-so. The learned senior counsel appearing for the applicant submits that the sole respondent writ petitioner had filed WPC number so-and-so, challenging the acceptance of the bid of the respondent number 5 in WPC number so-and-so in a tender process initiated by the ONGC for hiring of scrapping wings for Assam and Ahmedabad for a period of 5 years by a notice inviting tender number so-and-so dated 6/6/24. As per the NIT, a total number of scrapping units to be hired for Assam asset is 24 and for Ahmedabad is 14 units. For the said tender notice, the respondent number 5 in so-and-so submitted its bid in respect of 10 scrapping units for Assam asset, and the sole respondent writ petitioner submitted his bid for 2 scrapping units for Assam asset. The respondent number 5 in WPC number so-and-so became the L1 bidder as against the petitioner who was the L12 bidder. And accordingly, the ONGC had issued the notification of award to the respondent number 5 on 14/1/25.
L12 bidder. L12.
L12. Because there is a huge difference in rates.
Yes.
The learned senior counsel appearing for the applicant submits that the notification of award dated 14/1/25 issued in favor of the respondent number 5 in so-and-so has not been put to challenge by the sole respondent writ petitioner, and therefore the writ petition is not maintainable. However, this court, while issuing notice in so-and-so on 12/2/25, had passed an ex parte interim order directing the ONGC authorities not to proceed to allot the work order in respect of the NIT dated 6/6/24 for hiring of scrapping wage of Assam and Ahmedabad assets for a period of 5 years till the next date fixed. It is submitted that when the order dated 12/2/25 was passed, the ONGC authorities had already issued the notification of award dated 14/1/25 in favor of the respondent number 5 in WPC number so-and-so, and accordingly the interim order dated so-and-so passed by this court cannot be made applicable retrospectively to restore status quo ante. As such, the interim order dated so-and-so is liable to be vacated, modified. The learned senior counsel for the applicants also submits that as the NOA dated so-and-so is not put to challenge in WPC number so-and-so, the interim order dated so-and-so requires to be vacated, and the NOA dated so-and-so issued in favor of the respondent number 5 may be made subject to the outcome of the WPC number so-and-so. It is also submitted that the sole respondent writ petitioner had deliberately made false and misleading statements as well as suppression of material facts, and on this ground, the interim order deserves to be vacated. The learned senior counsel for the applicants further submits that the eligibility and experience of bidder is detailed in the bid evaluation criteria, BEC, referred to in clause 1.1A of the instructions to bidders. Clause A of BEC provides the vital criteria for acceptance of bids, wherein it is made clear that during evaluation of the bids, ONGC may ask the bidder for clarifications, confirmations, deficient documents of his bid, and the request for clarification and the response shall be in writing without any change in the price or substance of the bid. And if the bidder still maintains exception deviations in the bid, such bids shall not be considered and be rejected. It is also submitted that clause 24.2.1 clearly provides that during the evaluation of bids, purchaser may at its discretion ask the bidder for clarifications, confirmations, deficient documents of its bid. After the opening of the bids of the bidders, many bidders, including the writ petitioner and the respondent number 5, were given an opportunity by the ONGC to clarify, submit documents as per 24.2.1 and clause A of the BEC. He further submits that when the writ petitioner has taken the benefit of invocation of clause 24.2.1, he cannot question the action of the ONGC in extending a similar benefit to the respondent number 5. Further submission is made that the well scraping job is very essential for the ONGC as it is related to maintenance of crude oil production, and if wells are not cleared, there will be reduction in oil production which would affect the revenue of the ONGC. Therefore, delaying in finalizing the tender job would hamper the interest of the ONGC, and therefore the interim order dated so-and-so may be vacated. Mr. So-and-so learned senior counsel appearing for the sole respondent writ petition at the outset fairly submits that WBC number so-and-so filed by the petitioner is confined only with regard to the notification of award dated 14/1/25 issued by the respondent number 5 for hiring 10 scrapping winch for Assam asset. If I may pause here for a moment, this is still not under challenge. There is an application for amendment filed which is not yet to be allowed. The learned senior counsel for the sole respondent writ petitioner
this fairly submitted filed by the petitioner is confined only with respect to notification of award. With regard to the notification of award dated issued by the for hiring 10 scrapping bench. And for that amendment application.
they have done, once we pointed out that notification of award,
Challenging this.
they have sought an amendment of the writ petition seeking to bring on record this notification and challenge it. It is not even under challenge till now. And
amendment to
Yes.
the learned senior counsel for the sole respondent writ petitioner submits that the petitioner is a contractor who has executed several works for ONGC authorities, including rendering service for the hiring of scrapping winch for its oil wells, as and when required by the ONGC. Referring to the bid evaluation criteria specified in the NIT, the learned senior counsel submits that the bidder has to successfully execute at least one number of contracts with a minimum of 1 year duration in any of the services during the last 7 years in the oil and gas industries as specified under clause 2.1A of the bid document. He submits that some bidders has raised various queries in respect of the tender conditions, and to that effect, the ONGC has made its remarks to such queries. It is submitted that the documents furnished by the respondent number 5 pertains to the experience in respect of supply of manpower and maintenance, and not in respect of operation of hiring of scrapping winch. Therefore, the writ petitioner by filing so-and-so is questioning the decision-making process of the ONGC in favoring the respondent number 5 therein for issuing the notification of award to the respondent number 5 on 14/1/25 for hiring 10 scrapping winch in Assam for a period of 5 years when the respondent number 5 does not have the experience in respect of operation of hiring of scrapping winch. It is also submitted that in WPC number so-and-so, the petitioner had clearly stated in the writ petition that it was within the knowledge of the writ petitioner that notification of award has been issued to the respondent number 5 on 14/1/25. However, no work order or contract has been signed with the respondent number 5. They are still maintaining that work order has not been, but they are seeking to amend and challenge it now. As the notification of award dated so-and-so was not in the possession of the writ petitioner, the same could not be challenged in WPC number so-and-so. It was only after the present IA was filed, the petitioner has got possession of the NOA dated so-and-so, and accordingly has filed an IA being so-and-so praying for amendment of the writ petition. He further submits that no false and misleading statement was made by the petitioner in the said writ petition, nor was there any suppression of material facts as alleged by the applicant. He therefore submits that the interim order dated so-and-so passed by this court in so-and-so does not require any interference, and accordingly the present IA deserves to be dismissed. After hearing the learned counsel for the parties and without expressing any opinion on the merits of the case, this court is of the considered opinion The challenge made in so-and-so is with regard to the issuance of the notification of award dated so-and-so in respect of 10 scrapping wage for Assam asset only to respond number 5, which is an admitted position. They are themselves admitting that they are seeking an amendment. And the learned single judge records that this is the issue. And the petitioner is not concerned with the other units both in Assam as well as Ahmedabad. Any further opinion expressed by this court would have an effect on the merits of the writ petition being so-and-so, which is yet to be disposed of. After considering the entire aspect of the matter, this court is therefore of the considered opinion that the interim order dated so-and-so passed in WBC number so-and-so deserves to be modified. Accordingly, the interim order dated 12/2/25 passed in WBC number so-and-so is modified by directing applicants ONGC authorities not to give effect to the notification of award dated so-and-so issued to the respondent number 5, and the applicants are further restrained from signing any contract agreement with the respondent number 5 in WBC number so-and-so. So in an application filed by us, a relief has been granted to the writ petitioner, which is not even their prayer. They are yet to put the notification of award to challenge, and the signing of the contract itself has been now stayed. Way beyond the prayer that is even mean on record. If your lordship sees the prayer in the writ petition, that notification is not under challenge.
That amendment application.
Amendment application, my lord, we have given, it is not annexed, we have given it separate. 756. In fact, my lord, 756. In the amendment application, and even in the amendment application, there is no prayer for stay of the notification of award. The amendment sought is at paragraph 8. But before that, if your lordship will have a look at the last sentence of the paragraph 7. Here they are again changing the stand. In the writ petition, they say no work order has been issued and no contract has been signed. And in paragraph 7, your lordship will kindly see the change in stand. Last sentence, the notification of award dated so-and-so inadvertently not challenged as the same was not in possession. And thereafter, the prayer made is that the applicant states that his paragraph C is to be amended by addition of a line. The said paragraph C would be as follows, and they have added the last sentence. And there is no interim prayer for stay of that notification of award. And if your lordship kindly sees the prayer made in the amendment application, it is even more interesting. They are seeking to amend the something memo of parties in the writ petition being so and so by amending the prayer. See, I don't even understand the prayer. Allow the present application and allow the applicants petitioners to amend the memo of parties of the writ petition being so and so by amending the prayer. See, I fail to understand. But in any case, my lord, this application is yet to be even allowed. The learned single judge, without even a prayer for stay of the notification of award, has gone a step further and prohibited us from even not only state the notification of award, but for the contract also. If your lordship so desires, I can place the merits of the case also. It's a very simple issue, man. The respondent number.
No, why should we go into the merit when the matter is already pending?
Well,
Adjudication before the learned single judge. Why should we go?
there is another aspect on the conduct. The writ petitioner is a beneficiary of the same clause, 24.2.1, which is recorded. And what he does is this, my lord, the dangerous thing is done. If your lordship will kindly come to page 63. Paragraph 10 of the writ petition.
Yeah.
Line about 6 from top, your lordship will find a sentence starting ONGC sought certain clarifications.
Yes.
ONGC sought certain clarification from the petitioner pertaining to PAN card, GST, etc., which the petitioner clarified on 8/10/2024. It is to be stated that the petitioner only clarified the query of the ONGC and did not submit any documents pertaining to the technical eligibility. Now, if your lordship will kindly come to what actually he submitted, page 244. First,
244.
244, is the document he had submitted with originally with his tender. This does not fulfill the net worth criteria, this certificate. So he was allowed an opportunity to give a fresh certificate, which he submitted at page 243. This is an absolutely fresh document. Your Lordship will kindly see the date of the document. And this pertains to, it does not pertain to PAN or GST. It pertains to his net worth. And your Lordship will kindly see the date, my lord. 1/10/24. It was much after the last date of submission of the bid.
243 is not there.
243, my lord.
We have verified the audited financial statement under the relevant report of so the Rajiv Ajiga is not liable for statutory audit. He is sole proprietor of the concern, not the company. Since it is not a company, is not required to prepare consolidated financial as per the net worth of is positive.
Yes. So this is a net worth certificate which is required to show that his net worth is positive. And the date of the document is relevant, my lord. 1/10/24. He makes a statement in the writ petition that he did not submit any fresh document. And he says that it only pertains to PAN and GST. But this is a relevant eligibility criteria. If your Lordship so desires, I can show that clause also. That clause is at. So therefore, my lord, looked at from any angle without going into the merits.
I'll show it, my lord. 76 and 78, because the whole case which was projected for vacating of the order was that there was a suppression of material fact before the learned single judge while the order was passed. Because the notification, the award, NOA, we have not suppressed before the learned single judge while moving the matter. My lord will kindly see, this was brought to the notice of the learned single judge. Your Lordship will kindly see the order. Last order, NOA, it is at 14. Email, kindly see the email, my lord, which has been 209. 209. Kindly see page 78 words, my lord. Before your Lordship.
209 or 78?
No, first 78, then I will show 209. Please see 78. And 78.
Yes.
Yes, of the repetition. Para 22, my. Lordship.
Yes.
Not 78. Para 22, may I read, my lord? The petitioner has come to that one other participating bidder has complained regarding the illegalities and arbitrariness coming by the ONC in evaluating the tender before the so and so on 2/1/2025, especially in the respect of respondent 5. But ONC, instead of waiting for the hearing and outcome of the proceeding by EM, the ONC in a hurried and rushed manner published the technically qualified bidders and the BOQ on 3/1/2025. After waiting for a long period of time after opening of the bids on 2/8/2024. It is to be stated that ONC, after opening it and declaring the technically qualified bidders and publishing the BOK, have issued the NOA to the respondent number 5 on 14/1/2005 in respect of 10 units and decided not to proceed for the remaining 10 units Assam till the outcome of the IM hearing. This is quite irony as the complaint was against the respondent number 5. It shows that ONC is attempting to frustrate the interim hearing in order to favor the respondent number 5, who is a blue-eyed boy. The fact of the petition has come to know from inquiry made in the email dated so and so. Now, if your Lordship looks into the email that is at page 209, which was a part of the writ proceeding when we moved before the court. Kindly see 209. This is 14th, 17 of January.
17/1.
Yes, 209.
17/1/2020.
Yes. Just I read that in this, please refer to your trailing. In this regard, it may noted that so-and-so Mumbai has received requirement from so-and-so of tendering of hiring of scrapping winches for Ahmedabad asset, 14 unit, Assam asset, 24 unit, as an aggregated tender case. Accordingly, so-and-so finalized the tender by following all the tendering activities in so-and-so, and price bid for the said tender was opened on 3/1/2025. Thereafter, the bidder so-and-so represent the case. However, since the bid validity of L1 bidder for Assam Asset, South Asia Consultancy, that is response number 5, my lord, was only up to so and so, and the bidder didn't extend the bid validity. NOA was placed only to L1 bidder on 14/1/2025 in the interest of the ONC after requisite approval. So my lord will kindly note that because he bid validity was going to expire, so they want to extend. That is
We
why,
don't want to go into all.
no, that is
We
merit.
don't want to go into all.
Yes.
this matter.
Now the matter,
Yes.
before the, my,
What was the earlier order, initial order? passed
yes,
by the
I'll
learned
just show
single?
the initial order. My lord, I will show the initial order. Where is the initial order, please? Kindly see the next volume. Page
It is at page 237.
237, man. 237. What is that?
Read the order, sir.
Yes. The writ petition is filed challenging the steps taken to award the contract private. The learned senior premier submit that by way of a notice inviting tender published on 6/6/2024, the Oil and Natural Gas Corporation invited bid for work hiring of scrapping winches for Assam and Ahmedabad asset for a period of 5 years. The relevant dates for receipt of queries for pre-bid conference date or pre-bid conference date and time of the closing of tender and date and time of opening of tender were specifically mentioned in the tender. It is submitted. Date of opening and closing of tender as specified NIT dated 6/6/2024 was subsequently extended. The petitioner is a contractor who has executed several works for ONC authority, including rendering services for the hiring of scrapping winches for his oil wells as when required by ONC. By referring to the bid evaluation criteria specified in the NIT, learned senior counsel for the petitioner submit bid has to be successfully executed at least one number of contract with a minimum of 1 year duration of any of the services during the last 7 years in the oil and gas industry as specified under clause 2.1A1 of the bid document. Learned senior counsel petitioner submits that amongst the various work prescribed under clause 2.1A1 of the bid document, well scrapping or is a nature of work for which the present bid has been called for. He further refers to clause B.1, which specifies the vital technical condition which are to be strictly complied with, failing which the bid will be rejected. Mr. So-and-so, learned senior counsel for the petition also refers to various queries raised by some of the bidder in respect of the tender condition and the remarks issued by ONC. Subsequent to the pre-bid meeting which was held on 19/6/2024 and the discussion held thereafter, remarks made by the ONC in response to the query of the bidder as seen in the extract of minutes of the pre-bid meeting reflect that ONC has remarked the eligibility, experience and qualification criteria for providing services are related to the equipment and not to the operation and maintenance services. Mr. Das therefore submits any document or any credential furnished in respect to the operation and management experience are not to be considered for allotment of the present work. Mr. So-and-so referred to the certificate for satisfactory execution of the running contract issued by respondent number 5 by ONC in respect of the work executed by ONC for another contract. He draws attention of the scope to the scope of the work referred to in the said certificate to submit that the scope of the work indicates that it is for the supply of skill and highly skilled manpower for operation and maintenance work at the Kaveri asset maintained by ONC. It is submitted. The document furnished by the respondent number 5 reflects that the experience of respondent number 5 is in respect of supply of manpower and maintenance and not in respect of operation of hiring of scrapping winches. So-and-so refers to the extract from the portal dated 6/2025 to submit that shortfall documents were submitted by private respondent on 8/10/2024 in support of the experience, which is well after the tender closing date. He submits that as per the date specified in the NIT, the tender closing date, although initially was 16/7/2024, it was subsequently extended on 1/8/2024. He therefore submits that it is not permissible that the ONC authority ought not to have permitted the private respondent number 5 to submit document in support of his experience after the tender opening date. On this count itself, the bid submitted by respondent number 5 ought to have been rejected. However, it is submitted, the respondent authority are proceeding to allot the tender in respect of private respondent number 5. Submit the interference of the court is necessary to restrict the process undertaken by respondent number 5 for allotment of tender in respect of respondent number 5, who is not clearly qualified in terms of the eligibility criteria provided. It's considering submission so and so. Now, my lord will kindly till the next returnable date, the ONC authority shall not proceed to allot the work order in respect of so and so for hire of stepping of so and so for a period of 5 years. Now, this matter was moved on 12th of February 2025. Now, the submission which has been made was on 14th of January 2025. NOA has been issued.
14th
Now,
January.
January 2025. So the advancement, the argument which was advanced was that already the NOA has been issued. So the interim order which was passed was on 12th of February 2025. One, my lord, I'll submit before your lordship that there is no suppression or material fact.
Suppression.
Yes. Number two.
Okay, suppose there's no suppression. The court has passed order.
Yes.
While taking into consideration what circumstance.
Yes.
Show us from this
Yes.
order, in the law.
Now, my lord will kindly see.
The
NOA.
page number, mid of the page number 5, all your submissions have been recorded.
Yes.
Now come.
My-
It is submitted that the respondent authorities are.
I'm sorry,
proceeding
which
to
is the
allot
order?
the
Order,
tender.
sir? No, your lordship is, just now I am reading that order,
Page number 241.
241. Once. 241. Yes,
Come to the middle of this.
Yes.
On this count itself, the bid submitted by the respondent ought to have been rejected. These up to this para or up to this portion, the learned single judge has recorded your contentions only and nothing else.
yes, because that one is,
Since beginning, this learned single judge has recorded the contention of the petitioner and no finding at all.
Yes.
Now comes this paragraph. However, it is submitted that the respondent authorities are proceeding to allot the tender in respect of the private respondent number 5. Mr. D. Das therefore submit that interference of the court is necessary to restrict the process undertaken
yes,
by the respondent authorities for allotment of the tender in respect of the respondent number 5, who is not clearly qualified in terms of the eligibility criteria provided.
Yeah.
This is what
Right.
your submission and prayer.
right,
Earlier were the submissions in support of the petition, then the prayer. And learned, considering the submission made by the learned consider, let notices be issued and this stay order was passed.
Correct.
Suppose if there is no, without as you are admitting that there is no suppression on your part, but it appears, prima facie, where it appears to us that the learned single judge was, has passed the stay order taking into consideration your statement that since the matter has not been proceeded and the work order has not been issued, therefore status quo or whatever it may be, it should not be. In the clarification, the learned single judge has taken into consideration and almost admitted that yes, work order was already passed. Then he passed this order, okay, then work order is also issued.
no, what I'm saying, what we advanced and we made a statement, I'll show it, that there is no signing of the contract. What am my statement?
In
No,
this
kindly see
bulky
my
petition-
statement.
In this bulky petition, you have raised so many grounds and now you are saying that since you have pleaded and therefore the learned single judges might have taken into consideration all these arguments and without influencing with the fact that the work order is already passed, he has passed this stay order.
No, today, they have not signed the contract. That's what I made a statement.
Sir,
Kindly see,
when?
in the time initial in my read
Sir,
petition.
where is the consideration that
Read
learned
the
single judge
petition.
has taken into consideration this, that since the this contract is not signed and therefore I am saying this.
That's, my lord, that's what happens if this particular is given. No, your lordship will kindly hear it, then what remains in my read petition?
In your
It becomes
petition, in your
infructuous,
petition,
my lord.
not infructuous, sir.
Yes,
It's a tender of 5 years. The writ petition can be decided in a month itself.
no, that is why it has been fixed on 23rd of April.
Whatever
23rd of April, it has been fixed.
work order is.
My lord,
says
that was
in
a,
the year
my lord,
19
I'll tell your lordship,
Work
when
order
it
is
was,
issued in the way back in January.
my lord,
2025.
I'll tell your
And the
lordship
court,
what.
has issued an order in March.
No, they have given,
2025 states
no,
up
they
to
have
2
given,
months.
my lord, please, they have given extension to all the contractor up to May. 20 has been given extension, including up to May.
And apart from that, your challenge to the, this work order dated 14/1/2020 still is not in,
No, my-
paper books, sir.
No, my lord.
It is
please,
not in the challenge.
No, my lord, kindly see, well, whatever will be outcome, what we are saying, my lord, 3/1/2025, my lord, is technically, my lord, technically, financially, he was qualified on 3/1/2025. This is a consequence of that 3/1. Suppose tomorrow, my lord, can I put it this way, my lord? Tomorrow, 3/1/2025 is being interfered by the court. Then what happens?
Everything
Consequence
will
of the NOA will go, my lord.
Everything will go.
That's what we made a prayer, NOA consequence that it
Every-
will go.
Everything will go, sir.
No, that is why my submission, my lord, there is no signing of a contract. If the signing of a contract, then there is no question, my lord.
Why? What, how it
Signing
makes,
of the contract,
how it makes a difference, sir, even though if it is signed.
no, if it is not signed,
That-
that means, then where is the question, my lord? They have not mobilized also, my lord.
How it makes a difference, even if
Why?
it is signed, कैसे फर्क
No,
पड़ेगा?
my lord, what happens?
Then
Suppose
also the court
tomorrow,
can stay.
my lord, that your lordship can say now also. There is absolutely, this is not my particular, my lord. It can be said. No, what I'm saying that today, my lord, the matter has been fixed before the learned single judge. So your lordship can, normally your lordship remands the back and let it be heard in a period of 1 month, entire matter. How, my lord, with greatest respect, I'm saying, how it makes it, with great respect, I'm saying, how it makes a difference in 1 month if your lordship fixed up, dispose of the matter. Then what happens? If my amendment, my lord, they file an application for amendment. Allow, not to allow amendment, they file an application. It will be heard. My amendment application, they want to file an objection. On that day, they said, with a consent, we are fixing the matter on 23rd of February. The matter has been fixed on 23rd of February. Today, my lord, today is 9th. How, my lord, it's a matter, hardly matter of 15-20 days, my lord. 15-20 days, my lord. No, existing contractor is still, my lord, there. If your lordship looks into page 125, my lord, 125 is 30.0.
Yes.
Signing of the contract. But if the successful bidder is required to sign a formal detailed contract, ONC with a maximum period 30 days of so and so, until the contract is signed, a fax order shall remain binding among the two parties. In case of so and so, so and so, so and so. So there is no signing of the contract. My lord, the matter has been fixed. My lord, your lordship, my respectful submission is that if your lordship upsets the order of the learned single judge, what remains to argue for the learned single judge? It has been fixed. It has been fixed on 23rd.
Everything will remain, sir, on matter.
Nothing. Then, my lord, then if another multiplicity of litigation, my lord. Your lordship interferes with the order passed by the learned single judge.
Just the notification of award was dated 14/1/2025. The petition was filed on 12/2/2025, almost that, a month, at the end of the month. And as per this clause which you have now read, within 30 days, the contract has to be signed between the parties. At the back end, if such stay order is there, how can you say that has not been signed?
No, let
How
him
can
say.
it be signed, sir? How can it be signed?
Well, let it be signed, my lord, that is different, my lord, that they can sign. But they have not signed the contract the day when it was moved. They have not signed, my lord. They have not signed the contract. They have not signed the contract. And how, my lord, you kindly see, it has been fixed on 23rd. It has been fixed on 23rd. The matter can be taken up by the learned single and dispose of the matter, my lord. Absolutely no problem, my lord.
Okay, sir. That's all.
Just one thing I wanted to point out, same clause that my learned friend pointed out, 35, your lordship will kindly see clause 34. That mobilization period of 75 days, that is already over on 30th of March.
My lord, I
On
just.
14th of January.
Your lordship is asking, what is, I just 2 lines I'll say, my lord. The decision-making process was put to challenge. One, subsequent decision-making process which they have taken on 3/1/2025, allowing him technically qualified. Now that was, my lord, culminated into an NOA, which the original decision-making process was put to challenge of 3/1/2025. My lord, our whole case, we projected before the learned single judge, technically he should have been disqualified. Why, my lord, technically disqualified? My lord, this response number 5, if your lordship kindly take it 2 minutes, my lord, what is his, my lord, I'm not just going into entire merit. My lord, when he submitted the bid document, the response number 5, it was, my lord, operation and maintenance. Operation and maintenance in a particular by ONGC. It was not hiring of scrapping unit, is totally scope of the work is different. Now they said the last date of closing of the date was 1/8/2024. Only that for the clarification is only in respect to the nature of the work. It is not, because if you see, my lord, kindly 1 second, my lord.
Sir, why we enter into the merit?
No,
of
that
the
is,
case, sir?
no, today, why, my lord, it culminated.
Then it may prejudice case either of the
No,
parties.
no, what I'm saying,
Suppose
that
if we make
NOA
any observation,
no,
Mr. Das,
no, I
any
understand.
observation on merit?
No, I'm,
it would
no, no, what
prejudice
I'm
the
saying,
case of all.
decision making is process which culminated into 14/1/2025.
They will consider.
That's what I said. It culminated into 14/1/2025. So if decision making process on the face of it, I am saying, because your lordship is taking up the matter, on the face of it, I can show in 1 line that this is the document which is submitted, which, my lord, decision could not have been taken by the authority concerned on the basis of the document. Where is, my lord, they cannot give an opportunity. Kindly see 1 second, my lord. Kindly see that page. How it has been, my lord, will kindly see 267. Kindly see 267. Yes, my lord, kindly see 267.
Yes.
See this given to response number 5. See 1, my lord. 267.
Yes, sir.
267. This is addressed to the respondent number 5, 26/9/2000 at page 265. 265. See page 265 first.
Yes.
My lord, kindly see number 2. 26/4 to 26/9/2024.
Yeah.
In paragraph 2. Please note that submission of clarification, confirmation, deficient document should not be construed as qualification under the bid evaluation criteria of tender. The supporting document, wherever required to be supported by you in response to deficient document, confirmation sought by ONC should not contradict the details already given by you in the original bid. Also note, document to be submitted by bidder can be accepted subject to condition, basic structure of the bid and the vital techno-commercial BEC parameter on the basis of which the bid has been originally submitted should not change. Now kindly see at page 267. 267, my lord.
Yes.
See 1, bidder may be given one opportunity to submit document as per BEC clause 2.1 A1 to establish their eligibility and experience. Now, if you see their criteria which they have given, 169, see 169. 168. 168 is a type. One 168 can be looked into, 168. 168A. This is the original submission of bid by restaurant number 5.
Yes.
Kindly see, my lord, name of the work, brief scope of the work, operation and maintenance. To supply skill and highly skilled manpower for operation and manpower work. So this is by so and so. This dated was so and so, and the last date of submission was 1/8/2024. Now they corrected 174. Kindly see, my lord, 174.
Suppose that if he gives any finding,
No, this is what
what will happen?
my no,
What
no,
will
I
happen to that
understand.
reputation?
What my whole
What will
case.
happen to that?
No, today my whole case was that my lord, that decision making process was bad. Consequent to that, NOA goes. And clarification report, that's it. My clarification. You know, the clarification. And I will show my clarification which they sought for is not, my lord, changing the nature and scope of the work. Nature and scope of the work is not changing that.
Let it be decided by the learned single judge. Why you are asking for a second?
No, I was concerned, my lord, because of the order. If your lordship interferes and then nothing remains in my case, my lord. Nothing will remain in my case. That's the whole
Many
issue.
It is a learned concept. This is preferred on behalf of the films being agreed with the order dated 18/3/2025 passed by learned single judge in IA number 666/2025 in writ petition number
715.
5.
Oh, sorry.
715.
2025. Full stop. While writ petition number 7/1/2025, the respondent here,
Yes. Sole respondent.
the respondent here has challenged the respondent number 1 here has challenged the online list published on 3/1/2025 by ONGC notifying the financial rates wherein the respondent number, wherein the appellant was found to be L1.
Respondent number 2 is here.
Sorry, the respondent number 2 was found to be L1. Full stop. It was also paid that the respondent, the appellant, ONGC authorities be directed to cancel, recall, resign, or otherwise forbear from giving effect to the interim online list published on 3/1/2025, declaring the respondent number 2 herein as technically qualified bidder. Full stop. Certain ancillary reliefs have also been paid in the writ petition. It is contended that the writ petition was filed on 12/2/2025, and on the very same day, the matter was listed for hearing before the concerned writ court. The concept has submitted, the respondent number one has projected before the learned single judge that the proceedings to allot the tender in respect of the respondent number two has not been finalized, and therefore it is necessary for the writ court to restrict the process undertaken by the respondent, by the ONGC authorities for allotment of tender in respect of the respondent number two, who is not qualified in terms of the eligibility criteria provided. Full stop. It is contended by the counsel for the appellant that taking note of this submission made on behalf of the respondent number two before the writ court, the
Respondent number one.
respondent number one before the writ court, while the writ court, while before it, the writ court issuing notices to the ONGC authorities as well as the respondent number two herein has ordered that till next date, the appellant shall not proceed to allot the work order in respect of NIT dated 6/6/2024. Full stop. It is contended that as a matter of fact, the learned counsel for the appellant has invited our attention towards clause 33.2 of the NIT, which says that the notification of award will constitute the formation of the contract. And counsel has contended that as a matter of fact, in the present case, the notification of award, which means issue of work order, was issued on 14/1/2025 itself. But the counsel, the respondent number two, the respondent number one has not disclosed this fact before the learned single judge at the time of initial hearing, and has gave a statement and has made a categorical statement that the work order has not been issued in favor of the respondent number two, and therefore interference, therefore the writ court is required to be interfered. Full stop. Learned counsel has submitted that the learned single judge, relying on the said statement of the appellant, has passed the stay order on
Respondent.
12/2/2025. Full stop. Learned counsel for the appellant further submitted that an application was moved on behalf of the appellants before the writ court seeking vacation oblique modification of the ex parte interim order dated 12/2/2025. However, the learned single judge, despite taking note of the fact that before the issuance of the order dated 12/2/2025 by the writ court, before issuance of the interim order dated, ex parte interim order dated 12/2/2025 by the learned single judge, by the coordinate bench, the work order has already been issued, has proceeded to modify the interim order to the extent modified the ex parte interim order dated 12/2/2025 to the extent that the respondent, that the appellants are restrained to give effect to the work order or notification of award dated 14/1/2025, and also restrained from signing any contract agreement with the respondent number two. Stop. Learned counsel has submitted that the said direction issued by the learned single judge, wide order dated 18/3/2025, are absolutely unwarranted. It is also submitted that as a matter of fact, the notification of award dated 14/1/25, which amounts to issuance of work order, is not even challenged before the learned single judge because the amendment application preferred on behalf of the respondent number one before the writ court seeking seeking challenge to the work order notification of award dated 14/1/2025 has not been granted till date. Would stop. Learned concept has therefore submitted that the impugned order passed by the learned single judge, impugned orders passed by the writ courts dated 12/2/2025 and 18/3/2025 may kindly be stayed. Per contra, learned counsel appearing, Mr. D. Das, learned senior counsel appearing for the respondent number one, has vehemently opposed the writ petition and has submitted that as a matter of fact, as a matter of fact, the fact regarding the notification of award was very well pleaded in the writ petition before the learned single judge. And the learned single judge, after taking into consideration overall facts and circumstances of the case, has passed the interim order dated 18/3/2000, interim order, ex parte interim order dated 18/3/2025, as well as the order dated 18/3.
12th of February.
For 12th of February 2025, as well as the order dated 18/3/2025, whereby the ex parte interim order has been amended, has been modified. Learned counsel has further submitted that on merits also, the petitioner, the respondent number five is having a strong case because it is apparent that the respondent number two herein is not, was not eligible, was not technically eligible, but the respondent authorities have illegally declared him eligible for the contract, for award of the contract in question. So, having heard the learned counsel for the parties and after going through the impugned orders as well as the material available on record, we are of the prima facie opinion that initially the learned single judge has passed the ex parte interim order on 12/2/2025. Taking into consideration the submissions made on behalf of the writ petitioner to the effect that the notification of award or issuance of work order has not been issued till date, has not been issued, whereas the fact, whereas in fact, the same was issued on 14/1/2025 itself. Though the learned single judge, while modifying the ex parte interim order, wide order dated 18/3/2025, has noted and appreciated the said fact, but has passed further order, but has restrained the ONGC authorities to give effect to the notification of award dated 14/1/2025, which amounts to execution of the work order without assigning proper reasons. Full stop. In such circumstances, it is also to be appreciated that the notification of award dated 14/1/2025 has still not been has still not been put to a formal challenge before the learned single judge because the amendment application seeking interference with the notification of a preferred on behalf of the appellant. Respondent number one has not been granted till date. In such circumstances, we are of the view that the impugned orders passed by the learned single judge by the writ court on 12/2/2025, as well as on 18/3/2025 in IA's number, in writ petition number so and so and IA number, in writ petition number 715/2025 and IA number 666/2025 respectively cannot be sustained. The same are therefore interfered with and are set aside. However, the parties directed, however, it is made clear that the contract, the award of contract to the respondent number two by the appellant ONGC, which is questioned before the writ court, will remain subject to the decision of the, will remain subject to the final decision of the learned single judge in writ petition number 715/2015. Full stop. It is also expected that the learned single judge shall expedite the hearing of the writ petition.
Is only one correction is not, the case has been made out not by respondent number 5, respondent number 1. Your lordship has said respondent number 5, it will be respondent number 1.
Oh, we'll check.
Will respond number
We'll check it. We'll check it.
My lord, only one thing your lordship can fix it because otherwise again there will be problem. By within 2 months, the matter can be disposed of.
It doesn't look nice,
I-
sir.
within
If we give a command to the learned single.
No,
judge,
it's not a
request-
command. A request is being made to dispose of expeditiously as
Yes.
possible.
Right.
All right.
Yes,
And it deeply obvious.
Item 19.
Lordship against the order dated 4/12/23, my lord.
what's wrong in this order, sir? After 10 years, how can in 12 years?
Hmm.
What the adjudication is required to be done? If you have slept over their rights for last more than 10 years, what remains?
Lordship,
Anything else?
my lord, in this similarly situated person approached this honorable court, my lord, and I have,
When?
my lord,
When?
I have annexed, my lord, the order date, lordship, last,
You just show us when he approached the court and when the court was
lordship,
granted.
page 42, my lord,
Ah.
the petition of 2021, my lord,
42. What is it?
42, my lord. And those petitioner are disposed with the direction to consider my case as per
Which year? Which was the year?
as 21. 20,
Pending, the bill was pending since when? In this matter. Immediately, if you have approached the court, certainly the court would have granted the indulgence. But in the year 2012-13, you are saying that your bill was pending since 2012 and 13, and for the first time you approached the court in the year 2023, after 10 years.
My lord,
What remains?
my lord, as per my instruction, my lord, in those,
Delay is fatal
in those petition also, my lord, bill of 2012-13, my lord.
Where is that?
My lord, in
Where
the,
is that, sir?
writ
Here,
petition,
no, in this order, there is no mention of this effect.
that's true, my lord. Then, my
Then-
lord, I
No, no.
may be allowed to produce the copy of the
The-
petition.
That's all.
Lordship,
That's all.
Lordship,
The appellant has approached. The appellant has filed this writ appeal,
yeah.
being agreed with the order dated 4/12/2023. And even after passing of the order by the learned single judge, almost 1.5 years is now going on. And now you have approached this writ appeal.
Lord.
Delay, again delay, and again delay. What remains? against the Calicut. Passed in 6986/2023, whereby the learned single judges dismissed the writ petition. The appellant has approached the writ court with a prayer to issue a direction to the respondent authorities to release the payment respondent authorities the payment of pending contractual bills for the work executed way back in the year 2000, in the year 2012-13. Full stop. The learned single judge has dismissed the writ petition of the writ petition filed on behalf of the appellant solely on the ground of delay and laches, while placing reliance on a decision of the Honorable Supreme Court rendered in State of MP versus Bhai Lal Bhai, reported in AIR 1964 SC 1006. Full stop. Having the learned, counsel for the petitioner has failed to persuade us to take a different view in the matter as has been taken by the learned single judge. Hence, we are not inclined to interfere with the order of the learned single judge. Appeal dismissed.
Item 20.
Yes, what about?
My lord, in this case, my lord, tender open on my lord, 1st of April and only one bidder has come, my lord. Tender committee has been constituted and within 15 days, my lord, letter instruction received on yesterday, my lord. Within 15 days, it will be finalized, my lord.
Work order would be issued.
My lord, within 15 days, my lord.
Okay, list after 3 weeks. Let us see.
My lord.
Learned counsel appearing for the respondent has submitted that the tender committee has already evaluated the bid, single bid received from one bidder for the purpose of execution of the construction work, and it is expected that within next 2 weeks the tender would be finalized. List after 3 weeks.
Obliged.
Item 21.
None present. List in August. None present. List in. Stop. Okay. Stop. Thank you.